Today on Let Me Be Frank, we have a special guest and a dear friend named Fran Schanne. He's come on today to help us think about and help to explain some of the court decisions from the Supreme Court that came out last summer. Those include Dobbs v. Jackson, Kennedy v. Bremerton, and Carson v. Makin. So this is going to be a really interesting and hopefully educational conversation today between His Excellency and Fran Schanne. So keep your radio right here at 1350 AM or at 103.9 FM, or keep listening on the Veritas app on your phone. If you don't have the app, you can get it at the Apple App Store, the Google Play Store, or at veritascatholic.com. Let Me Be Frank is brought to you by a grant from Foundations in Faith. Foundations in Faith embraces innovative approaches to funding pastoral care programs in the Diocese of Bridgeport. Resources focus on energizing lifelong faith formation and discipleship and fostering a commitment to justice and accompaniment with our most vulnerable. From seminarians to retired priests, from baptism to last rites, from suburbs to inner cities, the reach is broad and the impact is meaningful. For more information, visit them on the web at foundationsinfaith.org. Okay, here we go. This is Let Me Be Frank on the Veritas Catholic Network. I'm Steve Lee, and it is my great pleasure, as always, to introduce Bishop Frank Caggiano.
Good morning, my friend. Good morning.
Hi, Excellency. Nice to see you again.
Good morning, Bishop.
Good morning, Fran.
Yeah. So, Fran, for our listeners, you heard a third voice. This is our guest for today. Let me give him a quick introduction. He's a gentleman named Fran Schanne, and Fran is known actually by many people locally here in the Bridgeport Diocese, but for folks outside of our community, Fran graduated from Villanova Law School in 1989, and he earned an LLM in tax in 1996. He spent most of his career as a lawyer to small business owners on ownership level matters, but he hung up his legal cleats when he went to work for a bank and then went in-house with a large private company. I know Fran to be a very good man, father of 6 children, faithful Catholic, and in full disclosure, Fran and his wife are dear friends of Rula and me. Fran is on today because we're going to talk about some of the decisions that the Supreme Court announced last summer involving life and also religious freedom. And while Fran is not necessarily a constitutional lawyer, he is a lawyer and he can bridge the gap between the legalese and understanding for us lay people who are not lawyers. So, Fran, thank you so much for joining us today.
Yeah, happy to be here. And it's really a thanks to Catholic education that I'm even here, because it was my kids in high school at a Catholic school that, prompted the principal to challenge me to talk about these issues once. And so I had to read up a little bit. And so I hope I can help. I'm sure there's some constitutional lawyer listening who's going to get sick to his stomach with maybe some of my slight misinterpretations or the exceptions to what I say. So with all due apologies to that person or persons, happy to help.
Fran, I'm delighted that you are here because for our listeners, I've had the great privilege of visiting with you and Andy and your family and having dinner a few times. And every time I come, our conversation is just fascinating. And the last time we were together, this topic came up. And I think it was between the main meal and dessert is when I said to you, would you be willing to come on the podcast and share this with the larger audience? Because I think you're very insightful about some key issues that I think most of us kind of intuit, but don't really spend a lot of time consciously, deliberately discussing, but they're very important to do that, right?
Right.
Yeah.
And it's good to know the framework so that you can have better conversations with people and find out, for high school kids, that's where I did my first talk on this, whether they have an interest in pursuing these things, because they're our future. They're the ones who are going to battle these issues in future courts and help or in legislatures and solve these problems.
So now there are 3 particular cases that I think sooner or later in our conversation we'll get to. But before I do that, I always ask a guest to talk about their own journey of faith. Like, how did you get to this point in your life, in your relationship with the Lord? You could share as little or as much as you want. But we just, it's always a great curiosity and encouragement to hear other people's stories.
Yeah, I think it's neat. So I was an altar boy growing up, and I had a strong fidelity to the notion of the priest who in my mind, was just one person removed from the apostles. The idea being that, they had meals together, and then they started masses early to do the sacrifice, and they passed it along. And I think of that phrase in the Gospels or in the New Testament where it's, and we say these things so you can believe, but there were many other things that happened.
Right.
And I always thought about, like, well, that handing off is those other things that happened, and to be connected to that was always important to me. But it was much more out of fidelity than out of, a deep faith kind of thing. And so what happened to me was, this gentleman whose locker was next to mine, he was retiring, and I asked him what he was going to do. He said, "I'm going to read the Bible." And I thought, that's interesting. Of all the things I would expect to hear, I didn't expect to hear that. And he said, you hear it every week at Mass, but I've never really read it to cover, and it's the most important book ever written. Why haven't I read it? And so that prompted me to say the same thing to my wife, who then got me one of these read a Bible page a day and get yourself through the Bible in a year. Took me 3. But it was seeing a different, like, the spiritual logic that was different from human logic, that made me think about the fact that that God is different than me. God is different than everything, and it got me curious, and to see if I could sort of prove God's existence in my life, and that sort of thing. And at the same time, just as I was doing this, or as I was finishing it, I overheard another lawyer talking about Bible study, and he was actually a Protestant. And they had this Bible study group, and so I invited myself, and it was a great, like, it just going through the Bible was so enlightening in terms of, what is it? You'll hear your master's voice and know it, and know the truth of it, and that for me was everything. Hearing God's voice.
And you have 6 children?
Yes.
Okay. And their ages?
The oldest is just turned 30, and I am a grandfather now. So, and she's my only daughter, and then I have 5 boys that range down through the 20s down to 11.
11.
So
wow.
young Robbie's 11. Yeah.
Yep. That's commitment to family life.
Yes.
All right. So now let us get to the matter at hand. So when we had dinner together, we were talking about the Dobbs case, right, which is the most recent case, one of the most recent cases at the Supreme Court.
Right.
And that has had a huge impact, right, both in substance and in cultural reaction. So give us the, if we were in a class, present what it was and what happened and why is it such a big deal?
Well, it's a big deal in that, I think, 2 reasons. One, people are worried about a notion of stare decisis, which is the thing has been decided. So they're worried about the fact that, Roe v. Wade was decided in 1973, and now it's, 50 years later, and it's being overturned. And so they're upset about the reliance aspect of it, which the court addressed. And they're also, I think, the notion of, I think there's well, that's probably the biggest thing they're upset about, besides the substantive matter of the right. The right is the thing that gets munged. So in order for there to be a right that the court really protects, it has to be a fundamental right, and there's a clear test for that. And so the court in back in 1973 sort of munged those things. And didn't address it the way they should have addressed it, and Dobbs addressed it the way they should have addressed it. It doesn't completely foreclose the opportunity for somebody to make a case that there's a fundamental right on the medical aspect of the choice that they're talking about, but the case was not made, and so the court essentially didn't want to be a legislature. They don't want to make the case. They don't want to do what the legislature should do. What the founders did when they did the Bill of Rights, they made the case for the rights that they wanted to assert, and that's for legislative bodies to do, and that's what the court said. So
in effect, what the Supreme Court, of course, I'm a layman in this, right? So
right.
What Supreme Court is saying is that they're not speaking to whether or not it's advisable or moral or good or to have the ability for a woman to have an abortion. What they're saying is it's not fundamentally a constitutional right.
Right.
Okay?
In order to be a fundamental right, there's a two-part test. It has to be deeply rooted in the history and traditions of our country,
Mm-hmm.
and then it has to be essential to the nation's scheme of ordered liberty.
Mm-hmm.
And so,
What do both of those mean? Give it to me in a simpler way, Frank.
well, so for example, the way they applied it in this case, they said, well, are there any state constitutions where there's a constitutional right to this choice? The answer was no. Are there, and so they looked to see what evidence there was of this is essential for us to live peaceably and to respect each other and that sort of thing. And so, the exercise of religion, the exercise of speech,
Mm-hmm.
the Bill of Rights trial, how you will be handled in a court of law, you'll have a jury of your peers, both, the jury trial right is both in the criminal area, but it's also in the civil area. So it wasn't
Mm-hmm.
just about taking your your own personal liberty away. It was also about how two people would interact if they were in a dispute with each other. And that was essential to ordered liberty. Even that private matter was essential to order of liberty. So they were looking for that evidence, and what they found was even what the Roe v. Wade court recited was abortion's been all over the place for a long time, and so there is certainly wasn't a reliance upon it as essential to an ordered liberty. There was actually a debate about it. And
Mm-hmm.
and they recognize in the Dobbs case, this is a deep moral question.
Mm-hmm.
And so it's one for the, to be hashed out in a quality way.
Which would be through the legislatures then.
Which would be through exactly.
Right. So now so as it stands now then, these months since the Dobbs decision, there is no national right, quote unquote, to have an abortion.
Right.
It falls back to the states. The majority of states have still legislated the possibility of an abortion in some way, in some portion of the term of a woman's pregnancy. But there are states that have restricted abortion and in effect outlawed it. Right. So now, let me play devil's advocate so that there's clarity here. There will people who will say, well, isn't that fundamentally unfair if I live in a state where abortion is now prohibited, and if I were to drive 50 miles to a state next door, that it is legal? Isn't that fundamentally unfair? What would be the legal response to that?
I think there'd be two legal responses. I think actually, I think it was the Webster case in 1979, where people were saying the same sort of thing about, whether there should be public funding of abortions.
Mm-hmm.
And what the court said there was, and that was a pretty liberal court, they said, no, there's no fundamental right to have a hospital. But if you have a hospital, you can't deny it. That was where they went to. So there's going to be unfairness. There's going to be different rules in different states that people won't like. And again, this is where you might need the constitutional lawyer to get a little bit deeper on it. But I think that would be my common sense answer to the question. We have to live with unfairness. I mean, there's a lot of unfairness. It's really just a question. Then go to the courts and work out the unfair. Or not to go to the courts, go to the legislature and say, hey, this is unfair. That I have to travel, and we're in rural Nevada or wherever it is, and it's our only cities aren't close to anything, and so therefore it's fundamentally unfair.
So another question then, just
it almost triggers that case in Maine about the the educational vouchers that was one on our list to talk about.
Which
There was an unfairness there that people saw, and they addressed it.
So as a matter of law, if a state in its constitution let's say, created an amendment or codified the right to have an abortion, can federal law overrule that state provision?
They can, but then the question is how, right?
Mm-hmm.
So, if there was a federal law that said, if the federal law said that we're going to ban abortions as a federal
Mm-hmm.
matter,
Mm-hmm.
then there'd be there's the supremacy clause and there's the notion of the commerce clause, and whether the state action would have to
Mm-hmm.
defer to the federal action.
Well,
I
the
mean, they have
reason
that right now. They have that with marijuana. Like, you have states that are allowing drugs to be used against federal statutes that ban controlled substances.
Right. The reason I was asking is it's actually for the opposite scenario, and that is, if a state says that in the state of X there is no state constitutional right to abortion, that we actually outlaw abortion, can the federal government overrule that? Is what I mean to say. If there ever were a federal law that passed and said, no, you have to have this. That's what I was wondering.
It's a good
Mm-hmm.
question. I think possibly yes.
Mm-hmm.
I think possibly yes.
Yeah. So that would still then,
but it wouldn't change, but then when the minority, then when the House and Senate switched, they could change that law, or if they did an executive, so that would go back and forth. It's really, what does it take to make a constitutional amendment to make it permanent? And
Mm-hmm.
that's really the interesting question to me. Mm-hmm. It takes 2/3 of both houses
mm-hmm.
would have to say that we are going to make a constitutional amendment one way or the other, pro or against. And then it would take, 3/4 of the states, 38 states, would have to ratify. And the interesting question there is, how would the states go about ratifying? If you look at a map of the election that even that Trump lost, it's amazing how red the map is across all the counties. And the battle seems to be right now is popular vote. If you listen to I was watching the TV last night in between the Yankees game, and they were and the newscaster on CNN was talking about, the coming to the unfairness of some of these elections and how they need to be, they're against the popular voice. Well, what they're really saying is the cities. In other words, if you look at a map of these decisions, you go across and you look at, wow, 90% of America all feel that, are conservative or something, and yet no, it's more 50-50. And there's obviously those independents that swing it one way or the other.
Right.
And so that's the dynamic, because state legislatures, a lot of them are on that county map.
Right.
And so it might actually tilt more towards the conservative view in that respect. But the question is, does your state allow referendums? And so people, lawyers, our students that are listening to this radio thing, the ones that will become our future advocates, they need to look at those issues, those electoral issues, for how they will affect, judgment calls that come down the pike.
One of the things that has always fascinated me is, this is my operational premise, and it could be totally wrong because I'm not a lawyer, but the structure of our government and the provisions of our federal constitution overlaid upon the culture in which we live and the state of society such as it is effectively impossible to pass a constitutional amendment in the current state of life. Because I'm not sure we could ever get to 2/3, 3/4 to agree on anything. Now, that may be pessimistic, and shame on me if it is too pessimistic, but I just think it's realistic. Right?
Well, I think it's overly pessimistic in the following sense, that I do think that that the opportunity is there if you're careful. So, for example, I think one of the states, I forget, was North Dakota or South Dakota, a few years ago, back before Dobbs, they tried to pass a law that was very conservative, and they argued over their conservatism. They didn't go far enough, so they couldn't get the law passed, and so it ended up being back in the old decision. And we find that happens even when we have the we just had both a Democratic House and essentially a Democratic Senate with the 50-50, and we had it before when Trump was there and he couldn't get some of his tax laws passed, whereas both Republican. And even when they have the House and the Senate and the president all lined up, they can't get stuff done.
Exactly. Amen. That's
and so
exactly
it's not that that it's hard to get to 2/3. It's the people not addressing things in terms of like really sitting down and talking, figuring them out. It's very around getting elected. It's very much around speaking to your base, and that's more important than the bigger issues.
Yeah. So to be clear, I agree with you. It's not the system or structure that's problematic. It's unfortunately, many times it's the individuals moving the process that is where the fault lies. Another question, if I may, before we go to the other two.
And what's interesting is, you know what it is? We can't tolerate badness. In other words, I was on a car ride talking about this radio session, and we were talking about when it was Roe v. Wade, and I was able to tolerate that badness in my mind, because it's badness in my mind because of my beliefs, not just about my religious beliefs, but my just beliefs about what we should be as people. Because of the Webster decision. The Webster decision in 1979 said that state has a compelling state interest in life from the moment of conception. And so because we have that compelling interest, we can then promote it. So as much as I don't like the law that people can get an abortion, I have a means to tolerate that badness and to try to make goodness happen. And so to me, I could tolerate, but see, the base, one way or the other, can't tolerate it, or the politician takes advantage of that. And it's our inability to tolerate some badness in the system, and to see what's good and to work with each other. Sorry, I digress a little, but it's
no. It's an excellent point, and I've always said on this podcast, and I've said in my homilies, and I'll say till I die, law has a particular purpose, right? So if it creates the threshold under which you should not slip to create a civilized society and protect mutual rights and the common good and all the rest, but morality asks you to live a life of virtue and grace. So law is not designed to be the sole path to get you right in right relationship with God and your neighbor. It's just a threshold you shouldn't slide under. So, I mean, could we ever imagine that no matter how the abortion debate ends in this country, however, it would never be used? It would never happen, regardless of whether it was possible or not, right?
Right.
And that sounds almost utopian, but that's ultimately what Christ calls us. That's what St. Paul says, right? When he juxtaposes the law and the spirit, he's not saying the law is evil, but the law in and of itself is insufficient.
Right.
Right. And that's, but one other thing about this question, which I'm fascinated about, and that is, Frank, correct me if I'm wrong, but on the federal level, there has never been any successful attempt to define the beginning of human life. Like, when does human life begin? Is that true or not true?
I think that's true. I think, well, in the cases I've read, it's true. So, in fact, even in Roe v. Wade, they went and they said, we're not going to address the question of whether this is a person.
Right.
We're not addressing. We're not even addressing whether it's a person. We will address the fact that when we look at the fundamental notion of ordered liberty, right, that this is not a constitutionally protected person. So when they looked at the Bill of Rights, all the people who had those rights were out of the fetus, were out of the womb. Sorry, you misused that word, but they were out of the womb people, and so and so those were the constitutionally protected persons that they ordered liberty required them to protect.
Right. So then, what would be the consequence if a Congress, U.S. Congress, passed a law signed by the president that actually defined the beginning of human life? Would it have an impact on all these other laws that we're referring to?
Yes, it would. I think, though, that, again, it gets back to, is it a constitutional amendment whereby you can't, a court could enforce it, to say that now a legislature can't change their mind on that just willy-nilly. So, we have their Bill of Rights, and it would take a constitutional amendment. You can't just simply pass a law saying, guess what? No guns of any kind anywhere tomorrow, right? Because it's in the Bill of Rights that you can. Now, there's a debate about what does that mean, but at least some gun somewhere is going to be allowed because of the Bill of Rights. And so if I passed a law, I couldn't do that. But if there was no Bill of Rights protecting a gun, then I could pass a law saying no guns tomorrow. And then 2 weeks later, a new legislature comes in and says, yes, you get a gun. And so it would flip-flop back and forth until you had a constitutional solution. So this notion of a constitutionally protected person being inside the womb, whether it's from the moment of conception or later, would require a constitutional amendment to get to the level that you're talking about.
Right. One other thing too. I have this vague recollection prior to the Dobbs decision that there are states where if someone murders a woman who is pregnant and is charged for murder, in some states the person can be charged for the murder of the mother and the murder of the unborn child. Is that true?
Right. I believe that's true. That's true. That's my memory. I mean, I'm at the same level as you.
Yeah.
Of that's my understanding. But
isn't that intriguing that there's an intuition in the law that says that fetus or that unborn child has the right to life because this person just took it away, even though in other venues we speak as if there is none. It's almost like a schizophrenia, right?
Well, it is, but it's also, there's the same schizophrenia with people. Like you talk about the moment somebody's pregnant and they're happy about it, it's a baby. And the moment someone's pregnant and they're unhappy about it, it's a fetus.
Right.
That schizophrenia is going on all over the place. The thing about the murder is just simply about what's constitutionally protected. Like it gets into that fine line. I think the blurry line is also another segue into those other cases about free speech and how people think of these things and they get them munged, and the court has to unmunge them and stick to what the federal court at the Supreme Court level has to protect and what it doesn't.
I think before we go for a break, there's just one thing I want, a little commercial, and that is what you said before, Fran. I think is extremely important for those who are listening to this podcast, and even those who are not, young people and others who are in the legal profession, whether they're lawyers or prosecutors or judges, those who are Christian, particularly Catholic in faith. These are the questions they need to think about within the prism of their faith, right? It is extraordinarily important that we not privatize our religion and say, just in church, I'm a Catholic, and when I sit on the bench, I'm not, right? Even within the limits of what's, appropriate or not. Otherwise, we will never have a conversation on the national level where people would disagree with us, but have an intelligent conversation of the very issues you're raising, right?
Right.
Yeah. So let's hope our conversation will incentivize many, to have that.
Very, very good. Let's take a quick break here. This is Let Me Be Frank on the Veritas Catholic Network. His Excellency is speaking with special guest Fran Schanne about some of the key court cases that were announced by the Supreme Court over the summer. And we'll be right back after the break.
If you're concerned about your end-of-life plans, searching for a Catholic cemetery, or have loved ones who are buried in one of the 14 Catholic cemeteries throughout Fairfield County, now might be a good time to begin planning for yourself or for other family members. Call one of our family advisors at 203-742-1450 and select option 5 to leave a message, or visit www.ctcemeteries.org. Many people don't realize that they can be buried with their deceased loved ones, even if all of the family's in-ground plots have been taken. The Diocese of Bridgeport Catholic Cemeteries provides in-ground burials, as well as columbarium and mausoleum options. This makes it possible to unite your family together in the same cemetery, and it's an opportunity to build a bridge for your family back to the church. Talking about this issue is not easy, but pre-need planning makes your wishes clear, reduces cost, and helps your family avoid difficult decisions at a time of grief and loss. You can start your planning now by contacting one of our family advisors at 203-742-1450 and select option 5, or visit www.ctcemeteries.org. We can guide you through the options, regulations, and considerations to help you make the best decisions for your family. The number is 203-742-1450 and select option 5, or visit www.ctcemeteries.org.
Okay, welcome back to Let Me Be Frank on the Veritas Catholic Network. We're talking with our dear friend Fran Schanne about some of the decisions that the Supreme Court released over the summer. Just finished talking about Dobbs v. Jackson, and I know, Excellency, you want to move on to a couple others.
Yeah, at least two others, if time permits. The one is the case that involves the coach and praying, right?
Mm-hmm.
So talk to us about what that case is, friend. What is all that about?
That's actually interesting in that the coach in that case, I read through the facts of it.
Mm-hmm.
It turns out that the coach was actually doing more than just, praying at midfield. Like the final decision was about the final act that got him fired, which was that he wouldn't, stop praying at midfield, right? And so that's what, after the game, after telling everybody they don't have to participate. But actually, there was a process. Initially, he was doing it much more than that in the locker room, in other situations. And the school board or school district, whoever it was, I don't recall specifically, asked him repeatedly to peel that back. And he did. He was like, you're right. Maybe this is influencing people, overly influencing them. I'm not here to establish religion. I'm just here to have my free religion. And so he peeled it back to this ultimate state where, they had hoped he would stop altogether, but he kept, maybe he had lawyer advice, but he kept taking a step back and eventually got to a point where he was really being very compliant and not establishing religion or coercing religion, but he was practicing his religion. And it wasn't good enough for the school district. And so then it ended up in the lawsuit. And so that's where, I think this is important for lay people, because sexual harassment or any harassment in the workplace has become such an important facet of employment, and good that it is, that we can work in harass-free places. And the law is evolving fast and furious in that area. And what most people understand is that when an employer is in a position of power,
Mm-hmm.
right, they can have influence, even indirectly influence, and they need to create a harassment-free workplace. And so what ends up happening, those people forget that religion is a fundamental right. It's different. It's protected. And we have to be mature people in our society to recognize that. And so that when somebody's exercising their free religion, that's protected. That's not harassment. And it might feel like coercion, might feel like the same thing, but you're going to have to live with that because that's a fundamental right. And so,
right.
And so that's what, it seemed to me, if I was going to be very favorable to the school district and say, they're not bad people, they're good people, and yeah, they were trying to do the right thing, I'd be saying that, hey, they were just trying to create that work-free, that harassment-free workplace. But what happened was they forgot, and maybe everybody's forgetting. This is why, we're on a call with the bishop of our diocese about our faith, and that's, I think people forget about faith. Maybe society's trying to kick faith out of everywhere, but it does exist, and it is a fundamental right.
Right. Now, so that raises one of my swan songs right here. And we talked about this at dinner, if you recall. Mm-hmm. I am of the opinion that secularism and the secular culture is actually a form of religion, and that it is not, in fact, the faiths being the traditional organized faiths versus this kind of amorphous, non-valued kind of free-for-all, But secularism is itself a set of beliefs, a set of
Mhm.
practices, and expectations of behavior. And therefore, for people to say, in the name of the secular world, we can't do this, well, then what you're really saying is, this religious practice I don't follow, but this one I will. Now, is there any validity to that paradigm in your
I,
mind?
well, I've been my wife gets me these books, and so the ones I've been reading of late have been about the 1800s,
Mhm.
and it's interesting. Like it, at least the historians write of that period, or maybe it's the Catholic historians that I'm reading that write of it in the same way. That really secularism became essentially a religion, and we've been fighting it ever since. And
Mhm.
it's what led to the revolution, and it because they were at that time, I think the church had a certain power that was different
Mhm.
than it is today. And so they were fighting that power with a new power, a secularism power. And what's sad about it is how who took advantage of it. There was a very small minority of people who really took advantage of it, so that they could become in power, and
Right.
so they took advantage of that spirit. So
Mhm.
yes, I think it's what you're saying is legitimate.
Mhm.
Um, I don't consider myself to be sort of I'm a little bit of a studier of people, uh,
Mhm.
as a
Mhm.
result of having been a lawyer and many clients and many trials and many
Mhm. Mhm.
cases, and seeing how people behave. So
Mhm.
I think there's truth in what you're saying.
Because then it raises the other issue in my mind, and that is, and again, going back to Dobbs just for a second, wasn't I think Justice Alito wrote that opinion and the summary judgment, and did he not say, if I remember, there's a difference between state hostility to religion, and I'm going to use my term, like a benignness to it. That is, disestablishment clause says that you can't establish religion. Doesn't mean that the state has to be hostile to religion,
Correct.
right?
Right. It's no coercion and no penalty.
Mm-hmm.
So you
Mm-hmm.
cannot coerce religion,
Mm-hmm.
which is the notion that I was talking about, the harassment-free workplace,
Mm-hmm.
that people might bridge, those two concepts. They might say, the munge them. They'd say, okay, well, it's an harassment workplace because you're forcing your religion on me,
Mm-hmm.
even
Mm-hmm.
though you're not really doing that. It's just an inferred thing. And that's why it's important to understand. I think the thing we're not talking about, which is really important for people to understand, is that there's the two biggest tests of when courts are looking at these cases are the rational basis test and the strict scrutiny test. And so when it's a fundamental right, the stakes get raised, and they say, okay, well, if the the state must establish it has a compelling state interest, something that's really important to protect, that's going to infringe upon this fundamental right, and they have to narrowly tailor their solution to that thing that they're trying to solve for.
Mm-hmm. Mm-hmm.
Okay. And so it's kind of easy to think of it in COVID times because, like, we didn't want to overrun hospitals.
Mm-hmm.
So you'd say, okay, well, my freedom, if I had a right of privacy under Roe v. Wade to not, to make my choices as to whether I wear a mask or get vaccinated or any of that stuff, certainly for some period of time, there was a compelling interest in having the hospitals work. And for some period of time, there was a compelling interest in managing the behavior of people to reduce that, and they could narrowly tailor it to that period of time. Then the question is, when does that expire? And so in the case of the Bremerton School District, Coach Kennedy, that case, they narrow they were on a path to narrow tailoring. They were like, well, not in the locker room, but like they could provide a disclaimer. They could say his views do not represent the views of management, and
Right.
so there's a lot of things they can do, and then it wouldn't be coercion. Like coercion can
Mm-hmm.
sound like harassment in the workplace, and then
Mm-hmm.
you could go down a path of the slightest thing could be coercion.
Right. See, in the end, I think, in my own kind of simple way of looking at things, if secularism is a religion and the state is obliged not to establish it, right, just as you described, okay,
Hmm.
right, to have benign neglect, if I could use that kind of term, But many times it is the secular culture and the liberty that supposedly it gives, and the willingness and the openness to diversity and all is cited sometimes in the more activist judges for ruling in a way that in fact is advocating a religious view.
Well, maybe I don't go that far, because I kind of bring it back to I'm a little bit of a, you know, a view people as trying to act in good interest, and I think it's more that the harassment-free workplace is what they're doing, and they're trying to promote all this diversity, or all it is as a notion of anti-harassment. And but if it was a religion, they would also have the right to practice their religion, and we can't
Correct.
coerce them, and we can't
Exactly.
penalize them. So
Correct.
so we
Correct.
have to live with that if we consider that to be badness, we have to live with it.
Correct. Correct.
And work within the framework.
Right. In a sense, the reason I keep raising this in my own mind is because when a religion is actually organized, it can become a target for many things. If you are disorganized or just an operational premise, you actually can be far more influential and subtle, right? With that, and having an effect, because there's nothing really to point to.
Right.
So it's a fascinating. Okay, so now,
Yeah, but I think that I think what's really neat is how we're having this conversation, and I'm presenting. You've taken the other side, I've taken the other side, and we're able to have a civil discourse about it, and it feels really good to me. I hope that this other people can have the same experience, that they can talk about these things even when they disagree.
Exactly, and quite frankly, in the end, if that dynamic is not reestablished in large circle in the United States, the whole functional notion of the common good is going to deteriorate. If we can't have a civil conversation of what ultimately is the good that we hold in common, how are you going to have a functioning society?
Right.
And we're beginning to see that. Anyway, so now talk to us about the other case, which is Maine. The Supreme Court made some waves in Maine recently. What was that about?
Well, Maine had a voucher system because they didn't have, they have a lot of rural areas where they may not have a school close by. And secondary schools are more expensive than elementary schools, and they require more facilities, and so they're further apart. And so what they said was that, essentially, if you don't have a secondary school in your district, and your district doesn't have a contract to provide, well, maybe it was busing or whatever, to get to another secondary school, that you could get a voucher and spend that on a school, as long as that school was two things. One, they had to be NEASC certified, the New England Association of Accreditation, whatever that stands for. And then secondly, it had to be non-sectarian. It couldn't be religious school. And so it was that thing that got some parents upset and some schools upset, to say, wait a second, why can some other private school get the benefit of these vouchers, but we can't? And what the Supreme Court said was that you're right. And this has come up quite a bit, where it's once you're discriminating solely on the basis of someone's religion, if you're distinguishing solely on the basis of religion, you are essentially blocking free exercise. And so you can't do that. And it's a pretty, these are the least interesting cases, frankly, to discuss, because it's so simple and so straightforward. What happens again, though, is that people feel that if dollars go towards religion, they're somehow establishing it, and they're somehow state-sponsored religion. And that's different. That's a bridge too far to say that, is what the Supreme Court said. But it hasn't been a bridge too far for other courts. And I think that gets into how much does your philosophical bias affect your decision making. So here we have three Catholic people talking about these issues. And so the listener, be interesting, I don't know who calls in, but is the listener hearing bias? Or is the listener here, is our predisposition to our belief in life or whatever affecting how we discuss these issues? I hope not. I'm doing my best to not have it do that, but it clearly did. It clearly did for some courts according to some
Absolutely.
higher courts. In other words,
Absolutely.
the Supreme Court said that it, essentially by the result of their decision, that it had clouded the judgment of a lower court. And these are supposed to be the best minds in our country.
Right. Right. See, I would say, again, in my mind, what is personal, what is private are different. And our faith is personal. It informs who I am. So as much as we want to be objective, whatever that means,
Mhm.
we do come with the prism of our faith. And I'm happy that we do that, to be honest. But so to understand the main decision, so even in my own mind,
Yeah.
if a state passes a law that says this whatever this is, privilege, benefit, money, subsidy, whatever, is only for public schools, it is what it is. But if the state says we're going to give this right, privilege, benefit to public schools and private schools that are not religious, that is fundamentally discriminatory against private schools that are religious. Is that
Correct.
That's
You
the difference.
can't distinguish one private citizen from another
Right.
based solely on their religion.
Right.
Now,
So
you could
I
say
think,
that one doesn't have a accreditation,
Mhm.
and it may be that it's a little quote unquote unfair because maybe it's harder for a faith-based school to get accredited because they're where they get their funding, and it's you've
Right.
created an unfair thing, and we might have to live with some unfairness.
Right. Right. The interesting thing is, for everyone who's listening to this podcast and for all the bishops of the United States, it would be interesting exercise to have their diocesan legal councils take a look at some of the laws that are there in their individual states when it comes to funding, educational subsidy, nutrition, counseling, nursing, all the rest, to see whether or not the provisions of those laws mimic Maine. That is, it's given to public schools and private schools that are not religious, but not religious schools, because you have the precedent that says you can't do that.
Yeah.
That would be a worthwhile exercise. We're doing that in Connecticut. I'm not sure if there's anything there, but it's worthwhile doing as an exercise to see. Right?
Yes, but what's interesting is that not every case gets heard by the Supreme Court.
Mm-hmm.
They deny certiorari in many situations where they just don't let the case get decided at the Supreme Court. And so you will see injustices in your mind. Like what'll happen is the path up to the Supreme Court may be through a certain bias that won't hear those cases and will decide
Mm-hmm.
them on fringe reasons. They'll
Mm-hmm.
and so they'll and it's interesting. When Webster sort of semi-overturned Roe v. Wade in '79, they overturned a part of Roe v. Wade. They were like, well, that wasn't central to Roe v. Wade's decision. Like they rationalized to
Mm-hmm.
make their decision, and so
Mm-hmm.
it's quite a battle.
Yeah, I mean, it's the application of the law is as complicated as the human condition is complicated.
Correct.
Right. So there will never be a time when everything is set, because as society evolves, right, technology evolves. Just the technological world now has created all of these questions that didn't exist 30 years ago.
Right.
Right.
And so then how do we behave? How do we use our faith
Mm-hmm.
and how do we use our principles to behave when it's that way and when it's that difficult?
Right. Right. And that is why when I was at Greenwich Catholic, and I celebrated Mass for the young people, and the scripture passage began with, I, Paul, a prisoner for Christ. And I said to the young people, I said, the prison, St. Paul was in prison for no other reason except that he was a Christian. I said, we can imagine that. But the point is, his response to that was not just seeking justice. He responded in charity. He wanted to forgive his enemies. The law can't legislate that. Only conversion can legislate that in your heart. It's the law of the Spirit. So as you say, I think in the end for us, this is extraordinarily interesting to me. This whole world I find it just fascinating. In part because, Fran, and I thank you for all your insights, it gives a clue to how society really, in the end, when push comes to shove, is operating and acts, right? And the values that in this given moment seem to be the preeminent ones. And the common good in our age, in this modern world, like in these last few decades, has taken a backseat to individual rights. And that is, with every action, there's an equal and opposite reaction. If we go too far down that road, we're going to get ourselves into major trouble, because you have to have the counterbalance, right, which is the common good.
Right.
So these conversations are really important, I think, to help keep that up in people's minds. Otherwise, going to the store and an iceberg lettuce is $5 for each one. It preoccupies my mind for 40 minutes, saying, so whatever happened to $1.99? And then suddenly all these other issues, there's no time to think about it. We got to make time to think about it. Right?
It's the economy, stupid. Is that that we're going to learn from today's talks? No.
My gosh. Okay.
This has been great. So you both can see, listeners can't see, but I'm wearing my coaching jacket right now. And
I saw it. I saw it.
We pray as a team on our knees before every game on the field. And I never thought about it, but I'm just waiting for somebody at one of the schools that we visit to complain,
Lee versus the state of Connecticut. I can see it now. A new case before the Supreme Court.
I just want to say, I see the word soccer on his shirt, and I can tell you, I played basketball with Steve. He plays basketball like a soccer player. So whatever so your team, so whoever's on your team there, so to make sure they don't go play basketball based on your coaching.
You know what? I think we need to go to a break. On that note, we will go to a break, actually. This has been a fascinating conversation talking about Dobbs v. Jackson, Kennedy v. Bremerton, and Carson v. Makin. We're going to come back on the other side of the break with a listener question. This is Let Me Be Frank on the Veritas Catholic Network, and we will be right back. Friends, this is Steve Lee with Veritas Catholic Network. I want to ask you to call us at 833-888-7884 and partner with us in the very important work we're doing for Connecticut and the New York metro area. Each year, we run 2 weeks of pledge drives in order to bring you 50 weeks of the outstanding, faithful Catholic programming you've come to trust and depend on. This week is Pledge Drive Week, so please call in. The number is 833-88-TRUTH or 833-888-7884. You can also go online to veritascatholic.com to show your support. Thanks so much, and God bless you. All right, welcome back to Let Me Be Frank on the Veritas Catholic Network. And before we get into the question, I just want to point out that Steve Nash and Giannis Antetokounmpo were both soccer players who played NBA basketball. Anyway.
But not Steve Lee, just for the record.
Darn. So, Excellency, this week's question is pretty interesting, and I guess it fits with kind of the legal theme of today's show. Mm-hmm. So it says, Bishop Frank, here's a crazy scenario, or maybe it's not that crazy. What if some layperson went into a confessional and pretended to be a priest? Would the sins of the people who went in and confessed to that person still be forgiven, assuming they sincerely believed they were speaking with a priest?
I think the simple answer to that question is no. No. If a person entered into that scenario and was perfectly contrite, that person's sins would be forgiven because of the perfect contrition that they had entering in. But in fact, without the I'm going to call the agent of grace that would impart in the name of Christ, in persona Christi, the words of forgiveness, the answer to that question is no. It would be no different than if a person very sincerely, if you, Steve, very sincerely believed that you were called to celebrate Holy Mass and you had everything there and you uttered the words of consecration, would it actually be the body, blood, soul, and divinity of Jesus?
No.
Right. In fact, that person would be guilty of a grave sin if they attempted to do that, because you're deceiving the penitent and you are receiving information that you have no right to, that is deeply deeply personal and is supposed to be protected by the confessional seal, which this person's not bound to because this person's not a priest. Right?
Wow.
So complicated answer to a very simple question, but I think the answer is no.
Yep.
Except if there was perfect contrition.
Makes sense. That person pretending would be in a lot of trouble from upstairs. Okay, so if you have a question,
He might also get in trouble downstairs too.
Yes, exactly.
If you have a question for Bishop Frank, send it in to us on social media, or you can email questions@veritascatholic.com. Bishop Frank Caggiano is on Facebook, Instagram, and Twitter, and so is Veritas Catholic Network. And we'd like to thank Foundations in Faith. It's a grant from the St. Therese Fund for Evangelization that makes it possible for us to bring Let Me Be Frank to you. Foundations in Faith is committed to supporting and transforming pastoral ministries in the Diocese of Bridgeport, and you can learn more about their outstanding work at foundationsinfaith.org. And Fran Schanne, thank you so much for coming on and helping us understand the legal implications of some of the stuff that happened last summer. And thanks for your continued friendship.
It was my pleasure. And yeah, as long as we stay off the basketball court, absolutely continues to be my pleasure.
Well, Frank, thank you. Every time we speak, I learn something new, which I think is tremendous. And I'm very grateful that you were part of the podcast. And maybe, please God, one day we'll get together for dinner again.
Excellency, would you please give us your blessing?
Yes, of course. In the name of the Father, of the Son, and of the Holy Spirit, amen. Heavenly Father, we give you thanks and praise for the gift of our faith in your Son, Jesus, and for the opportunity to live that faith in the world. Strengthen us and those whom we love, that we may always be faithful and courageous witnesses of the message of salvation in Jesus Christ. And may the blessing of Almighty God, the Father, and the Son, and the Holy Spirit come upon you and remain with you forever.
Amen.
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 All the best to you. Thank you.
Thank
Okay.
you.
Ciao, ciao.